Hi, very good morning. This is a Supreme Court judgment, again an interesting judgment under IBC, Insolvency and Bankruptcy Code. Citation Tata Steel Limited versus Varsha. Issue before the Supreme Court was whether operational creditors may enforce claims for the past dues by way of a civil suit or arbitration subsequent to approval of resolution plan. That was the issue before the Supreme Court. Facts, I have to give a little longer because facts are very important for this case. Bhushan Steel Limited is the corporate debtor. A corporate insolvency resolution plan, CIRP, was initiated. Prior to initiation of CIRP, a civil suit was initiated, say by A, an operational creditor, claiming some amount and interest. Similarly, some arbitration proceedings were initiated by B, another operational creditor. During pendency of the civil suit or the arbitration proceedings, CIRP was initiated against the corporate debtor. Both A and B submitted to jurisdiction of IBC court and lodged their claim before interim resolution professional. The interim resolution professional compiled an interim list of creditors. The claims of A and B were admitted. Then in that plan, a note was added that the claims are subject to outcome of ongoing proceedings, that is civil suit or the arbitration proceedings. Tata Steel Limited is the successful resolution applicant. Hereafter we will call Tata Steel Limited as SRA. Submitted a resolution plan. Since the claims of financial creditors exceeded liquidation value, the operational creditors were entitled to nil payment because the liquidation value is nil after paying the financial creditors. Nevertheless, SRA provided settlement amount of rupees 1000 crores for essential and critical operational creditors and rupees 200 crores for other operational creditors. Magnanimously, you take it on a pro rata basis. Resolution professional prepared a final list of creditors. Initially interim list, now final list. The claims of A and B were admitted at notional value of rupee 1. The note appended to the plan said that the claims which are subject to dispute are verified with a notional value of rupee 1. On the same day, the Committee of Creditors approved the resolution plan. NCLT also approved it. Appeals preferred by parties were dismissed by NCLAT. Subsequent to this, SRA moved an application before the trial court to dismiss the civil suit of A. Boss, resolution plan has been approved. Kindly dismiss this civil suit. Similarly, it moved an application before the arbitration tribunal, to dismiss the claim of B. But both applications were rejected. So SRA approached the high courts by way of writ petition. So two writ petitions, one before the Bombay High Court, one before the Punjab and Haryana High Court. Both were dismissed by the High Court. Then the SRA filed an appeal to the Supreme Court. So the principles, basic principles of IBC. Supreme Court examined the position of law. Supreme Court in JSW Steel held that all claims must be submitted and decided by the resolution professional. A prospective resolution applicant should know exactly what is to be paid in order to take over and run the business. Treatment of claims or creditors must be prescribed by resolution plan and approved by the Committee of Creditors. The wisdom of COC, that is Committee of Creditors, is non-justiciable. IBC code has overriding effect in event of inconsistency with any other law. Once the resolution plan is approved, the claims therein stand frozen and are binding on all stakeholders, including corporate debtor, creditors, government authorities, etc. Claims not submitted will stand extinguished, withdrawn, or abated to enable the resolution applicant to commence the business on a clean slate, free from unforeseen liabilities. NCLT or NCLAT's power is circumscribed by IBC code. They cannot assume the role of a court of equity or exercise plenary powers. These are the basic principles of IBC code, which has been seen noted by the Supreme Court. Then now whether the list is final, list of operational creditors, whether it is final. The final list of operational creditors prepared by resolution professional was never challenged by A. So he accepted it. B, even though he assailed it initially before NCLT, later that was dismissed as withdrawn. Against that, he did not prefer an appeal. Hence, the order has attained finality. Supreme Court noted this point, the final list prepared by the resolution professional. Then the second thing which was not taken into account was is the value of rupee 1 to the operational creditors. Is it to keep the claims, just to keep the claims alive? Supreme Court was of the view that no resolution plan can succeed if uncertain or unquantified claims are permitted to linger and resurface against SRA, that is the successful resolution applicant, years after the approval. Such a situation would be akin to Hydra-headed recurrence and is antithetical to clean slate principle. Supreme Court noted that final list was prepared by RP. That was approved by COC, subsequently approved by NCLT. SRA clearly said that there was no surplus and the liquidation value was nil, because financial creditors, after you pay the financial creditors, nothing is left. So the liquidation value is nil. Hence, SRA had no obligation to pay the operational creditors. Nevertheless, in spite of that, SRA gave 100 crores to essential and critical operational creditors and 200 crores for other operational creditors. So it is magnanimously given. You take it on a pro rata basis. Hence, the value of rupee 1 arrived was not just to keep the claim alive. It is not for the purpose of defeating the claims of the operational creditors. That is the opinion of Supreme Court. Then whether the plan approved provides for extinguishment of all subjudiced claims. So Supreme Court noted in the resolution plan, it was unequivocally stated that all legal proceedings initiated by or on behalf of operational creditors shall immediately, irrevocably, or unconditionally stand withdrawn. So in the note, resolution professional has clearly stated this: withdrawn, abated, and or extinguished. Further, it said, operational creditors shall have no right or claims against a corporate debtor in respect of period before effective date when the NCLT approved the resolution plan. Resolution plan did not carve out protection of subjudiced claims. Hence, all your claims, subjudiced claims, will get extinguished. That is what Supreme Court said. Then, on that basis, Supreme Court reversed the orders of the High Courts and held that all the legal proceedings which had not culminated in determinable, quantifiable claims by the date of resolution plan, it shall stand abated extinguished, waived, or withdrawn. Accordingly, Supreme Court said A and B was entitled for only 1 rupee, not more, even though their claims were some. In one case it was in crores, in one another case it was in lakhs, uh, 30, 40 lakhs, whatever it is. Then the Supreme Court made a suggestion to the Law Commission and the legislature to amend the IBC code for the MSMEs. Supreme Court was of the opinion that the IBC code does not adequately account for position of small operational creditors, including MSMEs, statutory legal bodies, etc., who stand significantly disenfranchised, that is, stripped of their rights. So don't see the dictionary. Disenfranchised, stripped of their rights under the present framework by being placed at the bottom of repayment of waterfall. So the water, when it flows, in the final, when it comes to the final stage, you may not get anything. Similarly, it is like this in the case of MSMEs and statutory local bodies. Most such entities are ill equipped to absorb even a minor financial setback because MSME will they will close down if some big person is not paying and they are getting only 1 rupee. Hence, court observed that the Law Commission should look into the matter to ensure a fair and balanced treatment mechanism for the MSMEs, and legislature should amend the law. That is the suggestion made by Supreme Court. My comments: the Varsha in Sanskrit means showering. So Bhagavan Mahalakshmi is as she's washing her blessings. That means she is showering her blessings by money. Unfortunately, in this case, there is no Mahalakshmi Varsha for the respondent Varsha. That is my comment. Thank you very much. Have a great and wonderful day. Bye.